to another episode in the podcast called Labor Matters, where I address trending topics in employment law, particularly in the context of Barbados labor laws. I'm Michelle Russell, attorney at law, and I have a passion for employment law and labor matters. I'm also a social activist. I write a weekly column for the Nation newspaper, which appears in the Sunday Sun, which deals specifically with labor matters. So if you want to learn more about your labor rights, be sure to get your copy of the Sunday Sun. Now, this week we are doing part 2 of the topic, sexual harassment in the workplace. Now, those of you who watched the first episode, you would know that we dealt with the definition of sexual harassment as found in Section 3 of the Employment Prevention of Sexual Harassment Act. But for the purpose of the podcast, I'm just going to call it the Sexual Harassment Act, but that's not the name of the act, wow, but just for brevity. Now, if you didn't watch part 1, I suggest you should go ahead, watch part 1 so that you can get a basic understanding of what is sexual harassment in terms of the definition, and we went into great detail, so I'm not going to do it for today's podcast. But for today, we're going to look at what steps can you take if you believe you have suffered sexual harassment in the workplace. But we're also going to address what can you do if a complaint of sexual harassment was made against you. What can you do if a complaint was made and determined and you didn't like the result of the complaint or the decision, whether you're the complainant or the accused? What steps can you take to appeal it? And we're going to look at stuff like false complaints of sexual harassment, as well as victimization for having made a complaint. So let's start at the top. What can you do if you believe you have suffered sexual harassment, which falls within the definition of Section 3 of the Act? And like I said, if you're not sure what that is, go back and watch part 1 of the podcast. We got into great detail for that. Now, the first thing you should know is that Section 4 of the Employment Prevention of Sexual Harassment Act requires that every employer implement a policy against sexual harassment in the workplace. Now, the policy must essentially be in keeping with the legislation, and it essentially tells you what items should be contained in that policy, including, and it's found in the schedule, so the content of the policy against sexual harassment, and what items should be included in such as the definition of sexual harassment and the procedures that employees can take to make complaints of sexual harassment. So that if you suffer sexual harassment, the first place you should look to learn what the procedure is for making a complaint for sexual harassment in the workplace is to go to HR or to your supervisor or your employer and say, where is this policy against sexual harassment? Now, the reality is you should already know about that policy, because Section 4 of this act actually created an obligation on employers to roll out that policy within 6 months of when this act was first implemented. Now, this act was implemented at the end of 2017, so November 2017. So that employers had up to about June 2018 to have implemented this policy against sexual harassment, and employers who have not implemented the policy could be liable to a fine of up to $5,000. So if you're saying, well, Michelle, I've never heard about this policy, my workplace doesn't have a policy, it means your workplace is in breach of Section 4 of the Sexual Harassment Act, and they can be liable to a penalty of $5,000 in the fine. So that you can go to HR or your supervisor or your employer and say, well, where's this policy against sexual harassment? I understand that there should have been one, and if there's not one, then they really need to implement it, because they're far outside of the 6-month timeline, because June 2018 was 4 years ago. So that's step 1. You should be able to resort to reviewing your internal policy against sexual harassment to see what the procedures are listed therein for making the complaint. But in any case, any procedures in that policy must comply with the requirements of reporting that are found in the legislation. Also, if the policy for whatever reason is deficient and doesn't contain a procedure, then you can have resort to the legislation. And if you want a copy of the legislation, and you don't mind driving or taking the bus and going somewhere, you can go to the government printery that's on Bay Street, and you could just ask for a copy of the act. It's probably like $2.50. It's not expensive, more likely less than $10. Or you can go on the Ministry of Labor's website, go into the part marked library, and they should have a copy of the legislation. Now, the first thing is, if you believe you suffered sexual harassment, you can have resort to Section 7 of the legislation. And that essentially requires that you would make a written complaint to the employer. Now, Section 8 of the legislation goes into more detail and tells you when, how, and some timelines. So that if you believe you suffered sexual harassment that falls within the definition of Section 3 of the Act, step 1 is you must notify your employer within 3 months of the occurrence of the sexual harassment. So it's a fairly wide time period, but understand it is limited to that 3-month time frame. So you can't wait too long to decide if you want to file the sexual harassment complaint. But more importantly, it should not be a verbal report of the incident. It should be a written report. And in the event that you are worried that your business is going to be across the office, the legislation actually places a heavy duty of confidentiality for sexual harassment complaints, so that the name of the complainant and the details of the complaint are supposed to be kept absolutely confidential, except insofar as it might be necessary to investigate the circumstances surrounding the complaint. So that when you make this written complaint of sexual harassment, it should be treated with the utmost confidentiality. And if the employer breaches that confidentiality, they can also be fined under the legislation. So step 1 is the written complaint must be made to your employer. Now, the internal policy should tell you who, whether HR, your manager, etc. But if the sexual harassment is by your manager or by HR, naturally the complaint should not have to go to them, and you would have to put it to someone above them. So step 1, within 3 months, send a written complaint of the circumstances surrounding the sexual harassment, and the information surrounding the circumstances must be kept absolutely confidential. If the employer or any of the employer's agents, employees, etc. breaches that, the employer can be liable to a fine. Now, after you give in that written complaint in that 3-month time frame, the employer must notify the accused employee within 2 days of receiving the complaint. So if you file that complaint on the Wednesday, by the Friday, the accused should be notified of the complaint and be given sufficient details to be able to respond to it. And then after that, the employer must commence investigations of the complaint within 14 days after it was originally lodged. And I think it's good that the legislation placed these time periods on it, because it makes sure that these complaints don't lapse or end up not being investigated at all, or it just takes too long. Because you have to remember that, especially for these kind of events, some of them can be traumatic and your memory can fade over time. So that when you have these short time frames of you must report it within 3 months, the accused must know it in 2 days, and they must commence the investigation within 14 days, it puts some pep in the step to make sure that the employer takes action, and takes action relatively quickly. Now, the legislation doesn't say when they should complete the investigation. But if they start it within 14 days of the complaint, they should complete it within a reasonable time thereafter, depending on how many witnesses they have to interview, etc., etc. After the investigation is completed, the employer then has to make a determination of the complaint, which is essentially determining whether or not they believe that sexual harassment was committed. Now, the Act gives the employer very wide powers, and this is one of my pet peeves with the legislation. It doesn't tell the employer what to do, except it simply says, after investigating the complaint, the employer may take such steps as it deems necessary if it finds that the accused employee was found guilty. So that the employer might come to the determination that there was sexual harassment, or that there was no sexual harassment. If there is no sexual harassment, it's simple, the matter should end there. But if the employer determines that the accused employee was guilty of sexual harassment, then the employer has this wide power to do or take such action as it deems necessary. So that leaves the employer to determine if they're going to give them a slap on the wrist, a warning, institute disciplinary measures, termination, etc. I do believe the Act is deficient there, because if you leave it up to individual employers, you might find some people treat it overly harsh and some people treat it overly simplistically and dismiss certain complaints. Now, if after you go through all of that procedure, you are dissatisfied with the result of the investigation, you are allowed to appeal it. But before I go to appeals, let's talk about what happens when sexual harassment is from your employer itself, because so far we're making certain assumptions. We're assuming that the sexual harassment is from a co-worker or perhaps a superior. But what happens when it's from the boss, like the CEO? How do you file a written complaint internally, knowing that everybody is paid by the boss and people might be afraid to make a determination in your favor? Now, this is one of the good things about the Act. It essentially says where the complaint of sexual harassment is against the CEO or your employer, then you can bypass the internal processes and you'd make the complaint straight to the chief labor officer. Which means the first time the CEO would find out about the complaint is when he is contacted by the chief labor officer. And I believe this was put in place to ensure some measure of objectivity, because it would be really difficult for employees who fall under the purview of the CEO to make a finding against the CEO, if only from the discomfort that would bring. Now, if you make a complaint of sexual harassment, or you are the subject of a complaint of sexual harassment and you don't like the result, then you would make an appeal. Now, a complainant who is aggrieved by the decision of the employer may appeal to the chief labor officer within 3 months of the decision. But if it's a case where you made the complaint to the chief, and I mean in a situation where it was your employer who you made the complaint against, and say the chief labor officer makes a decision that you are not satisfied with, then your appeal would be to the tribunal. And appeals from decisions of the tribunal would be made to a judge in chambers. So that you have certain resort in terms of decisions you don't like. And bear in mind, appeals can be either by the complainant or by the accused. So both parties have the opportunity to have a second eye or a second ear into these complaints of sexual harassment. Now, let's look at what are the powers of the chief labor officer for when complaints are made to the chief. The chief labor officer has to follow a very similar procedure like the employer has to follow where an internal complaint of sexual harassment is made. The chief labor officer must notify the offending party in writing. He has a discretion to carry out investigations in the matter, and he should try to resolve it by mediation. He can make inquiries as is necessary, and he actually has very wide powers under the legislation to request documents and the presentation of witnesses, etc. And if there is no settlement of the matter, the chief can refer the matter to the tribunal. Now, suppose you made a claim for sexual harassment and you changed your mind for whatever reason. You do have the power to discontinue the complaint, so that any claim that is lodged with the chief labor officer alleging sexual harassment can be discontinued at the complainant's request, but it can also be discontinued at the discretion of the chief labor officer, where he determines that the complaint is trivial, frivolous, or brought in bad faith, or where the complaint was not lodged within the 3-month timeline. Now, it's very interesting to give the CLO such powers as to determine what is trivial, frivolous, or in bad faith. And, but we have to trust that there will be objectivity when the chief is assessing these complaints. Now, what happens if you assist your colleague in making the complaint of sexual harassment? So suppose you just happen to be a witness to the events, and your colleague comes to you and says, well, I was uncomfortable with this, I'm going to make a report to HR. Will you give a statement on my behalf? The legislation actually protects those who assist a complainant in making the complaint, and protects those who appear as witnesses, whether internally for the investigation or hearing of the complaint of sexual harassment, as well as those who have to go to the tribunal or go before the chief labor officer to assist in investigating the complaint of sexual harassment. So that Section 26 of the Act prevents an employer from threatening, punishing, denying employment opportunities, or adversely affecting the employment conditions of any person who rejects an employer's sexual advances, or any person who lodges a complaint of sexual harassment, any person who participates in investigations or proceedings connected to the complaint, any person who gives testimony in relation to the complaint or gives information in the proceedings. And any employer who is found guilty of victimizing an employee in any of these circumstances would be liable to a fine of $10,000 or to be imprisoned for 2 years or more, or both. Now, this is good because what it does, the aim of the legislation is to ensure that people feel safe to bring complaints of sexual harassment. And that is why it protects the confidentiality of the complainant and the accused and the circumstances surrounding the complaint, but it also prevents the complainant from being victimized for having brought the complaint. And it protects those who assist in the investigation and assist in the proceedings, whether by giving information, giving testimony, attending hearings, etc. So that any employer, if you feel you're being victimized because you made a complaint of sexual harassment, or if you assisted in that complaint and you feel you're being victimized because of it, then you can actually make a complaint to the Chief Labor Officer, who can investigate the issue of victimization. And if the employer or any of its agents or employees are found guilty or found to have victimized any of those persons, then the employer might be liable to be fined for $10,000. But what's also important is that if you make a false claim of sexual harassment, it is found to be false, and we trust this will be based on good evidence. If you make a false claim for sexual harassment, you can be liable to a fine of $10,000 or imprisonment of 2 years or both. So it is important that you don't use the legislation as an avenue for revenge or anything that it was not made for. So, in summary, if you believe you have suffered sexual harassment in the workplace, because remember the legislation only covers sexual harassment in the workplace. If you feel you've suffered sexual harassment in the workplace, you should be able to have resort to your policy against sexual harassment, which every business should have had since June 2018. If it doesn't exist, you have every right to go to your employer or to HR and demand that one be instituted and draw their attention to Section 4 of the legislation. So you should be able to have resort to that legislation and check to see what the procedure is in the policy, resort to that policy and check to see what the procedure is in the policy for making complaints. If the policy doesn't have a procedure, or at the very least the policy should comply with the procedure under the legislation, which requires that you make a written complaint within 3 months of the occurrence of the event. 2 days after you make the complaint, the employer has a duty to inform the accused, but keeping the information strictly confidential except as is necessary to investigate the complaint. And then the employer must commence investigations within 14 days of the complaint. The employer then would make a determination on whether or not sexual harassment has been made out. If they find there was no sexual harassment, then that is essentially the end of the matter unless it's appealed. If they find there was sexual harassment, then the employer can take such action as it deems necessary against the offending party. However, if the sexual harassment was committed by the CEO or the boss, the biggest boss, the complaint is not made internally. The complaint must be made directly to the Chief Labor Officer, again in writing, and again within 3 months of the occurrence of the event. If a decision is made on the complaint of sexual harassment and you are dissatisfied with the decision made either by your employer or by the Chief Labor Officer, you have the opportunity to appeal within 3 months of receiving that decision. The appeal from the employer would go to the Chief Labor Officer, but the appeal from the Chief Labor Officer would go to the tribunal, and any appeal from a tribunal decision would go to a judge in chambers. Finally, if you have made a complaint of sexual harassment or you have assisted someone who made that complaint and you feel like you are being victimized by your employer as a result of making the complaint or participating in the complaint, then you can make a complaint to the Chief Labor Officer saying, look, I've been victimized because of this. The chief can investigate the circumstances, and if the employer is found guilty, then the employer can be fined $10,000. If you make a false claim for sexual harassment, you also can be liable to be fined $10,000 or be imprisoned for 2 years or both. So, like I said, if you don't know what sexual harassment is, watch part 1 where we went into great detail. But I do encourage all of you to get au fait with sexual harassment, because you want to avoid instances where you are accused of sexual harassment so that the workplace is a safe environment free from sexual harassment, where you don't feel like you're walking down the road or you're in a fit where every time you barely turn somebody trying to whine on your bumper or touching you in ways that you don't want. So it is very important to get knowledgeable of the legislation. You can get your own copy from Bay Street at Government Office, or go online on the Ministry of Labor and learn what your rights are. If you think you're suffering sexual harassment, don't be afraid to take steps and report it in the hope that it will cease, or contact the Labor Office. You can contact me and we will see what can be done about it. So thank you for joining me for another episode of Labor Matters. And remember, knowledge is power. The more you know of your labor rights, the more empowered you are in your employment relationship. See you next time. Bye.